Yeah.
Recording has started.
Yes, yes. You all can see me properly? I'm okay? Is it visibility is okay?
Yes, sir. Yes, sir. You're visible. Yep.
Yes. Yes. Shall I keep the camera a little more down? Just see
No,
that. Is it okay? This is better or the earlier one was better?
this is okay, sir. Your face is visible. Your whole this is visible.
Okay,
This is
okay.
proper.
This is proper now. Okay. Then okay. Yes. Uh, what provision we covered last time? Any idea? And you have anything? Evidence we were covering the provisions of section 294.
Sir, we are supposed to start with CrPC 315 onwards.
300.
15.
Okay, okay. Yes. Yes. Yeah. Yes. After the prosecution evidence is completed, as per the provisions of section that is trial of the session trial, so which began from 225 onwards, the prosecution commences witness the evidence after the charges are framed and please record it 230 onwards and evidence of the prosecution 231. Then if the learned judge is not convinced with the evidence of the prosecution, acquittal is accorded. If the learned judge is satisfied with the evidence of the prosecution, he may ask the defense to enter. If there are circumstances against the accused, 313 will come into play. We last time mentioned to you how the accused will be called into box. Ask him to explain the circumstances appearing against him in the evidence. 313 statements are not evidence. That we learned it here. Oath is not normally regarded because it is not a evidence under the Evidence Act, and he will not be rendered to perjury. That is subsection 3. Then the answers given by the accused may be taken into consideration. The court may help the prosecutor. Yes. 315 we were to start with, and that. Then accused will be also entitled to examine his witness under section 315. In all the trials, the after the when the session judge as well as the magistrate is not satisfied under the provisions of a trial before a court of session, the section 315 should be read along with section 233 in a session trial case. Please note that. 315, a list of witnesses will be given by the accused person. And I mentioned to you that under the Evidence Act, the learned magistrate will give a direction as to which witnesses to be examined first, what are the documents which are to be admissible, non-admissible. He will pass order under section 135, 136. So when the accused is, so there are 5 trials here in the court. First, number 1, in a trial before a court of session, section 315 is invoked by under section 233. Remember this. That is where the prosecution, the defense enters the witnesses. Okay? Then in a trial before a magistrate, in cases instituted on a police report, that is under chapter 19, the provision for entering defense is 243. Section 315 CrPC should be read along with section 243, where the accused, this provision we have already dealt with, I won't again repeat. Just bear in mind, where the accused is entitled to lead evidence, then second trial, that's the third trial. I mean to say that the trial before the magistrate in cases otherwise than a police report, that is commencing from 245. The provision for leading evidence is section 247. 315 to be read along with section 247. The list of witnesses are given here. Then the fourth trial, that is a trial of summon cases in chapter 20, section 315 should be the provision for recording evidence is because in a summon trial, you know that here the charges are not framed. Then the provision is the provision for the section 254. Please note that procedure when not convicted. The magistrate does not convict the accused. The magistrate shall proceed to hear the prosecution and the evidence as may be produced in support of the prosecution as well as the accused and take evidence. So the 254 postulates the evidence of both the prosecution as well as defense. Whereas in a case of a trial before a court of sessions and a trial before the magistrate in warrant cases, there is a separate provision. Whereas in trial of summons cases, in one section 254, the evidence of both the prosecution as well as the trial is of the defense is a club together. That means section 315 should be read along with section 254. Then finally, in a summons trial, the procedure for evidence is led under section 262. Again, there are no charges framed here. 262 should be read along with section 315 of the CrPC. Please note that. This is not to be read in isolation, section 315. It should be given a harmonious interpretation along with section 261. Then ultimately 315 ke alawa, I also mentioned to you, after the completion of the evidence, even before the stage, till the stage of inquiry, trial and judgment is given, the prosecution as well as the accused has the right to summon any material witnesses. 311 is very important, bear in mind. Uske andar anytime. Even the police officer, after filing of the charge sheet, has a right to say that I have collected more material. I have collected more material and I may be permitted to reinvestigate the matter in the matter. So, example, in a murder case, only there must be 5-6 accused. Only the police officer could trace one or two of them. Later on, when the matter is kept for judgment or before the judgment is pronounced, he will take up the plea that here I have also arrested the final accused who was a party in the conspiracy. He was also hashed the conspiracy. Then he will make an application under section 173 subclause 8 for a further investigation. Once further investigation is given, then there will be further evidence. Further investigation ke baad there will be further charges. Further charges ke alawa, then both the prosecution as well as the defense will have opportunity. Again, you are relegated back to the provisions of section 315 and the relevant provisions in the trial. Please note that here. Under 311, all material witnesses will be examined by the court. Then that is how. Then I mentioned to you, specimen vara ho gaya. 315 is very important. Then ye yahan pe trial power. Then the appellate court power to examine witnesses, because sometime when the matter goes in appeal, the appeal is always the continuation of the suit or a continuation of the trial proceeding. Please note that the appellate court may say that here the material which has come on record is not sufficient. And the magistrate or a court of session has not recorded the evidence correctly. They require more material for conviction. So I am remanding the matter back. May the appellate court, the sessions, if the appeal is gone to the court of sessions from the magistrate or from the to the High Court from the judgment of the Sessions Court, or gone to the Supreme Court from the judgment of the High Court, the appellate court may take further evidence. Please open section 399. It's a very important section. I will read it for you again. In dealing with any appeal under this chapter, the appellate court, please note that appellate court has a power to reopen the facts and reappreciate the evidence, but not the revisional court. Revisional court does not have power under the provisions of the 397-401. Neither court of session nor the magistrate nor the High Court can reappreciate evidence. Whereas in appeal, which is filed against conviction or against sentence, the appellate court has power to further examine the matter. So 391 के अंदर देखिए, dealing with the appeal under chapter, the court, if it thinks additional evidence is necessary, shall record it reason and may either take such evidence itself, direct to be taken, or when appellate court is so and so. Please remember 391, when additional evidence is taken by the court of session. So these are all the relevant sections in CrPC for the purpose of recording evidence. Now I will take you through, I mentioned the criminal manual. When you open, if you have got, I sent it to you, this criminal manual. देख लीजिए. If you are having Aditya, देखो जरा खोल दीजिए. उसमें the relevant section. This is the for the guidance of the lower courts, subordinate court, namely the court of session, judicial magistrate first class, second class, metropolitan magistrate. The High Court has given direction under this year. Some of them, because there are many directions under the CrPC, but I will only point out the relevant for the purpose of recording evidence and identification. Now, how the witnesses are to be attended and granted, it is starting. Bombay High Court has framed this rule, and if you are having open this, number one, yeah, I will first take it as very important provision. One of the how identification parade is done. सुने ना आपने? How? Because at the time when the accused are arrested, there may be 10 accused, 7 accused. Witnesses, whether they are able to identify them, unless you are able to identify, they cannot be convicted. So there is a special provision for who can take. You should know under the CrPC scheme, उसके अंदर नहीं लिखा गया है. Who will conduct the identification parade? Identification parade is held normally when the identity of the accused is not proper, doubtful. Suppose the crime has taken place in Churchgate station, और ट्रेन से उतरने के बाद बहुत से लोग देखे ये killing भी, and many commuters were examined by the police officer, and many of them, they don't travel every day. Some of them travel randomly, and they may say that we have seen. But at the time when FIR was lodged, and from the time evidence was recorded, and when the time the trial commences, there must be a substantial gap of 5-10 years, whether you still record it here. So what should the police officer do? After recording the first information report, while he is conducting investigation, he must invite an executive magistrate. Please note that here is a magistrate who does non-judicial work. Executive magistrate, that is when you see that rule number 16 in the Bombay High Court criminal manual में provide किया गया. How identification parade is done is please remember this item number 16 में बताया गया है. The statements mean the executive magistrate, he will be invited to the police station or the maybe a judicial lockup. In his presence, 10 people will be invited, all the people, and you identify who is the person who killed whom. suppose the statement at the time when statement was recorded under 161, he says the accused was about maybe around 35 years of age. His complexion was wheat complexion, and his height is around 5.5 feet. He has particular marks, so and so. So police is under obligation to bring that accused, and along with him they will mix 5, 6, 7, 8 people similarly looking. Why? Because the witnesses should be able to identify the exact man. Of course, if the witnesses know him from the very beginning, alag baat hai. If there are strangers who are seen for the first time the accused in a commission of crime, if they cannot spot him, he will be acquitted. So that the reason is that here the innocent people should not be trapped. The police or the witnesses should not, the police witnesses should not trap an innocent man. Because that is why in a criminal prosecution, the prosecution must be established the case, prove the case beyond reasonable doubt, unlike the civil cases which are on preponderance of possibilities. So that reason, for the keeping in mind, the executive magistrate who does non-judicial work or a special executive magistrate is requested by the police to come and watch the parade, and in his presence the identification take place. Police will tell him, the magistrate will ask the various people here, you participate, did you see the crime at the time you were there? Yes. Please point out who is the accused. Many times you see in the court of law, sessions court ke andar, the accused person is covered with faces. They are wearing a burqa. Burqa means they are not pardanashi ladies. The accused identity is kept close, so that when in the case of a doubt, he should not be trapped. He should not be wrongly prosecuted and convicted. So the witnesses will have to identify. Now the statements made by the accused, made by the witnesses during the identification parade are not evidence strictly under the Evidence Act. They will be statements under section 162 of the CrPC. That means the deponent who was present in the jail at the directions of the executive magistrate to identify the witnesses. After identifying, when the trial begins, this is a pre-trial arrangement. Please note that the identification parade takes place under the Identification of Prisoners Act. I told you last time that you should keep it in mind. So ये करने के बाद, when the trial commences after framing the charges, the same witnesses will be asked to come, because the magistrate will prepare the memorandum, which memorandum may be admissible under section 80. May not be admissible. The accused may take up the plea that nobody has identified me, I was not present, and the statement of the gentleman who saw the offense, who stayed different from what you can, a good cross-examiner can demolish him. So the statement, the identification parade के साथ में जो statement होते हैं, whatever he has seen, whatever he has deposed, must be proved as per the Evidence Act. That means the witness must come and depose as a direct witness under section 5960 of the Evidence Act. So the evidence of a person who has seen it, evidence of a person not who heard it, direct witnesses. These are all direct witnesses, which will be best witnesses. That evidence, the statements which he gave under 162 CrPC are sought to be now corroborated. Only when the witness dies before giving evidence, his statements can be used under section 32 of the Evidence Act as dying declaration, was a different matter. Okay, please note that. Item number, the clause number 16 in the Bombay High Court Criminal Manual is important for identification parade. Next is a memorandum is prepared. If page number 82, if you are having a criminal manual of the year 2019, I can give you the exact page also. Otherwise, I'll give the relevant clause number. Say पेज नंबर 82 है. If it is tallying with you, my mind, I do not know whether it is tallying. If it doesn't tally, no problem. I will give you the number under the memorandum is prepared by the magistrate as per rule number 82 के अंदर है वो. रूल नंबर आई विल गिव यू द एग्जैक्ट रूल. वो उसी रूल के अंदर आता है. which rule number? Rule number 54. Sorry, I'm sorry, wait here. Yes, rule number 16 के अंदर ही आता है. And memorandum is prepared. There is a description of the memorandum is given in the schedule, which can be used under section 80 of the Evidence Act. Now the next, see how confessions are, because you know under section 164 CrPC, the magistrate record. Now the High Court is directing the magistrate how you should record the evidence. That is at page number 84 of the manual it is mentioned. When you see that here, clause number 17 के अंदर confession दिया गया है. Please note that here. That is clause number 17 में how the magistrate must inform the accused. You are not supposed to make the confession. If you make the confession, you will be convicted. I hereby warn you, don't make it. And if you do that, you will be. If you still insist you want to make it, go ahead. I will record. He should record verbatim in his own language what he says that. Then he will seal and prepare the memorandum under 16 and proceed. Then how the witnesses, the rules regarding witnesses are page number 121 में आ जाएंगे आप. If your page is tallying with me, otherwise not mine, then I will tell you that is a relevant clause number is Maharashtra. एक मिनट, page number 120, 121. Yes. You are having your pages are tallying with mine? आदित्य, पेजेस टैली हो रहे हैं आपके हमारे?
121 नो सर.
देखो सॉरी, महाराष्ट्र पेमेंट ऑफ गवर्नमेंट एक्सपेंसेस कंप्लेनेंट एंड विटनेसेस अटेंशन एक्ट रूल नंबर 1980 का है ये. पेज नंबर कुछ 1 बॉम्बे हाई कोर्ट पेज नंबर 121 है इसके अंदर. अथॉरिटीज पे इन एक्सरसाइज ऑफ पावर अंडर 312 CrPC द महाराष्ट्र पेमेंट ऑफ एक्सपेंसेस. और विटनेसेस को बत्ता चार्जेस पे करते ना आप. When you call it, that is the procedure for payment. So I will not deal with it much. It is not required. Then the next, how the other witnesses are examined. Please come to traveling handwriting expert के बारे में 143 पे है.
No sir, no.
Not there. They are not telling with you. I am giving you the rule number. The rule number in the rule number handwriting expert के लिए rule number 27 है. A rule, a clause number, whatever you may say that. The summons to medical officer is a rule number 23. Rule 23, these are all summons to medical officer. Rule number 23 मिला आपको? मिला?
Summons no sir, this is
no, it is
this is the criminal manual by
criminal manual issued by the High Court of Judicature at Bombay. नहीं मिला?
1 second sir.
It is there, issued by the High Court Bombay. I am 19th edition में मैं देख रहा हूँ. That is गुप्ते एंड दिगे का है. तो देखो
सर 27 में क्या था? रूल नंबर 27.
Rule number 27 speaks of a handwriting expert. Authority of the court to issue summons to appearance to the government experts. वो है आपके पास? नहीं. If they are not tallying, I won't waste my time on this, because you will not be able to understand this.
I'm trying to look for it, sir. I don't think there is there.
Then page number 1 नहीं है. That means ये नहीं लेंगे फिर हम लोग को. आपको बताएंगे, तकलीफ हो जाएगी. Because I don't think from the examination point of view will be relevant to you. It will be good for practice. When you become a practicing lawyer, please go for criminal manual and civil manual. Keep it, okay? Now these are the rules in of the evidence in the CrPC. Now, the Code of Civil Procedure खोट लीजिए. These are the so far evidence rule. 391 appellate court का हो गया. Huh? Oh, isn't it? Anybody want to ask me any questions so far in CRPC evidence? Is that clear? Then now I will straight away take to you how evidence
Sir,
is recorded.
hello.
बोलिए.
Sir, different
बोलिए.
different high court have it their personal manual, na? Like
Yes, yes, you
Bombay
are
High
right.
Court. So it's not statutory law. It's a personal manual ruled by Bombay High Court.
Yes, every high court under Article 227 of the Constitution of India and its supervisory powers, they issue this manual. Okay, because the high court is the superior court, which is giving direction to the various trial courts and trial court as to how should to do. Yes, CRPC के अंदर भी एक provision है, इसके अंदर I'll point out to you. Section 483 खोल लो. 483 CRPC. Duty of High Court to exercise continuous superintendence over the courts of judicial magistrate. Okay. Every High Court shall exercise superintendence over the courts of judicial magistrate, subordinate as to country. There is an expedition, proper disposal of cases. Now, this section should be read along with Article 227, superintendence by the High Court. So that will cover not only civil court, criminal court, all tribunals in Maharashtra. Each state has its own High Court. They will frame the rule. समझे ना आप? And the Supreme Court has its own Supreme Court rules. Okay, remember it here. Yeah. So what you should remember for recording evidence in the CRPC, section number 1 under the Evidence Act, section 137, examination chief, cross-examination, re-examination. Then list of witness, section 135, 136, where the judicial magistrate, in the absence of a provision in CRPC, will direct who are your witnesses and how your documents to be admissible. Then the procedure to be complied with for recording evidence is a more specific. Chapter 22, 23, section 273 से लेकर 272 से लेकर, we read it right now. Section 299, special provision. Then 301 से लेकर 302. Then some of the provisions which are 311. Adjournment नहीं आएगा. Then next provision is 315, 313, 313, 312, 315. Appellate court powers are section 391. This all you should remember it. And Evidence Act के अंदर, of course, I have pointed out to you the various sections. The definition pointed out. Evidence Act will be applicable to all the judicial magistrate who can record evidence. Executive magistrate cannot do that here, isn't it? Then remember the provisions of may presume, shall presume, and conclusive evidence, definition of evidence, isn't it? Then confession and admission. Admissions are applicable to both CPC, evidence, civil procedure court, as well as criminal procedure court. And confessions from section 24 to 30, 32, 31, they are applicable to only criminal matters, confessions. And character evidence may section 51, 53, I read out to you last time, or some of them are applicable to CRPC, criminal cases. Criminal cases के लिए section 53, 53A and 54 and 55. Civil cases के लिए civil cases character evidence is irrelevant. Character is evidence is specially is applicable to civil cases, criminal cases, sorry. That is a section 52 से लेकर 55. That chapter remember करो. And admitted facts need not be proved. बाकी everything applies to criminal prosecution. Section estoppel, that is 115 and 116, essentially apply to civil cases and not to criminal cases much. There is no estoppel against the crime. You cannot take up the plea that here accused is estopped from contending so and so. Whereas in a civil case, you may take up the plea that the plaintiff made a concession, he has not taken action for long time, he should be estopped. Limitation to apply karega. Baki sab, then provision relating to may presume, shall presume, that is 114, 79, 80. Then cross examination question 145, 146, 153, and declaring witnesses hostile 154, all will apply. Just cursorily you need not know. But CRPC ke andar what you should know exactly, more important, the provisions from starting from section 272 onwards till 299, specific provision. Thereafter 313, there are 315, 15, that is very important for the evidence of the. Then 17 bhi padhe humne, trial in the absence of the accused. Then the power to proceed against other person, 319, when a person is not joined in the FIR. Then police officers to reinvestigate the crime under 173 subclause 8 is very important. Usko dhan lijiye aap. This is very important. And appellate powers to examine the witnesses, 391, which are akin to, analogous to in the CPC under order 41 rule 27. Now this is the entire procedure. And trials before the court of sessions court, and trial before the magistrate in warrant cases on a police report, trial before a magistrate in otherwise than a police report, number 3, then trial in summons cases, trial in summary cases. 5 trials, please remember them. Wahan pe sab evidence ke provision lagti, which I pointed out to you. Okay, I am now closing the CRPC evidence. In between, now I will take up, because the evidence in civil cases, that you will remember, because I'm not sure, have you been covered by the evidence in civil cases by your professor teaching you Evidence Act by CPC? Cover ho gaya? Hello?
Yes, sir.
Has your professor taking CPC touched upon the topic on evidence?
Sir, yes, some part of it has been done for one class. Other class, I'm not sure, because 2 classes are here together.
What topic you have covered? Let me know. What portion you have covered?
Evidence.
In the CPC, how the evidence begins? After framing of the charges, after framing of the issues under order 14.
Yes, sir.
Order 14. Now uske baad order 10 ke andar evidence is recorded. Do you know that? Any one of you know? Order 10
sir.
Order 10 ke andar evidence is recorded. Before framing of the issues, evidence is recorded. Please open order 10. ये सब important चीजें हैं, जानना चाहिए. Please note that. What are the stages when the civil court can record evidence? I am giving you. Please open order 10. पहला order 10 खोल लीजिए. पहला framing of the issues to सीख लिया, order 14. You all remember it, isn't it? I won't touch upon it because that chapter. Order 10 किधर देख लीजिए. Order 9 हो गया. Yeah. See, order 10 में आइए. Examination of parties by the court. मिला ना आपको? Have you got it?
Yes, sir. It is on the screen.
देख लीजिए. See, examination यहाँ से शुरू होता है. At the first hearing of the suit. Anyone knows when is the first hearing of the suit? Have you been told? The first hearing of the suit in CPC is from the day when issues are framed. Please underline this word. ये CPC में नहीं लिखा है. When from the when where are the issues framed? Under order 14. Order 14 किए या नहीं आपने?
Yes, sir.
Order 14 comes into play when plaint has been filed, written statement is ready, pleadings are completed. When pleadings are completed, the court will frame the issues. Before framing the issues, evidence can be recorded under order 10. See that? Ascertainment whether allegations in pleadings are admitted or denied. Court will only frame the issues if the claim is admitted. The court will pass a decree on admission. क्या बोलेंगे? Under order 12. And if they are denied, the trial will take place. Now see, at the first hearing of the suit, mean at the day when the court is sitting for framing of the issue, the court shall ascertain from the party or his pleader whether he admits or denies the allegation of the facts are made in the plain or written statement of the party and are not expressly or by necessary implication admitted, denied, party against whom they are made. The court shall record such admission and denial. So this court will record the admission and denial and give a finding on that. Suppose you have filed a suit, plaintiff has filed a suit for a claim of rupees 10 lakh. Defendant bolega, I am liable to pay only, I took 6 lakhs only, not 10 lakh. So there will be decree on admission for 6 lakhs. Okay, next. Then see here, order 10(1)(a) के अंदर, it is now mandatory for the court before going for trial to direct the parties to go for settlement. That is arbitration, conciliation, mediation, lok adalat. I won't read it. Under section 89. Section 89 के अंदर 5-6 मोड दिया गया है. Court will say that if the parties go for settlement, go for mediation, go for lok adalat, it is now mandatory. The court shall tell the court when the mediation conciliation fails. देखो 1C, appearance before the court, failure on the efforts. जब fail हो गया, then the court will proceed. Where the suit is referred to so and so, presiding officer, conciliation is satisfied. In the interest justice to proceed with the matter, then it shall refer the matter again to the court, direct the matter. When conciliation has failed, the matter will again come back. Then the court will now record evidence, order oral examination of a party or companion party. Now this is at the first hearing of the suit, that is at the time when the matter is set for framing of the issue. The court shall, with a view to elucidating the matter in controversy in the suit, examine orally such of the parties to the suit appearing in the court or present in the court as it may deem fit. Now, while in the CrPC, while framing a charge, it is not obligatory for the court to examine the accused person or anybody. Isn't it? That you have seen, we read it from section 211 onward. Now, यहाँ पे it is now made obligatory. The court orally so and so, the court can record evidence here. May orally examine any person. It is a discretion of the court, not mandatory. But what is mandatory? Sending the matter for settlement, for conciliation, mediation, arbitration, and for lok adalat is mandatory under order 10, rule 1C. वो fail हो गया तो the court is at liberty to examine the parties. Please note that order 10, rule 2 is very important. At any subsequent, a court may orally examine any party. Court may think fit in the course of examination under so and suggest the parties. Yeah. This is one stage. Even before the framing of the issues, the court may examine the parties, then consider the issues. ये होने के बाद, this procedure is a exercise, then the provisions of it, the court may say that here issues are being framed under order 14. Under order 14, when you open,
sir,
please.
सर जैसे कि वो इन्फॉर्म, मतलब ये मैंडेटरी है जजेस के लिए कि सिर्फ उसको इंट्रोड्यूस करना कि आप आर्बिट्रेशन में जाओ या मीडिएशन में जाओ, बट इट्स नॉट डिपेंड ऑन द पार्टी, इट्स नॉट कंपल्सरी फॉर द पार्टी.
and the party may has to go, but party may refuse it. बोलेंगे party मुझे नहीं जाना है. It cannot be called. Now open section 78 जरा खोल लेंगे, उससे मिल जाएगा आपको. When you open section 89 खोल लीजिए of the CPC. देखो arbitration 89 में, what 89 is interesting provision which should be gone into. See that here.
Settlement of
88
dispute outside.
Yes. Where it appears to the court, there exists an element of settlement which may be acceptable to the parties, which may be. The court shall formulate the terms of settlement and give the parties their observation and receive a so-and-so. Court may reform possible settlement, refer the same to arbitration, conciliation, judicial settlement, लोक अदालत. ये एक्सरसाइज करना जरूरी है. Even arbitration के अंदर arbitration section 30 arbitrator also under section 30 of the Arbitration Act requests parties to go for settlement. Then 39A of the Constitution of India में भी provision है इसके अंदर. देखिए आप where the article 39 के अंदर वो the providing mediator or not important for that. So section exercise to section 89 is made compulsory by the provisions of order 10 rule 1A. The party may say that I do not want to settle, the terms are not attractive, I will be a loser, but the procedure has to go through. The court must give an attempt, because the attempt is made to see that the matter is explore the possibilities for an amicable settlement. वो नहीं हो गया तो then again the matter will go for trial, so that the court will frame issues under order 14. Please note that here 10 के बाद then the parties may be told either if the issues are not framed or framed, they will be directed to file their affidavit of documents. Discovery inspection देख लीजिए आप. Next step is, it is also trial का procedure. Discovery mean both the parties should take inspection of their original document, and inspection discover what new facts, additional facts are come, because in the plain and written statement when you file, you are supposed to enclose all the documents, and if you don't enclose the document, you will not be allowed to use in evidence without the permission of the court. Permission के बाद you can do it here under discovery inspection, and you have to file the affidavit of documents. Please note that under order 11 rule 13, it is mandatory that the parties must file the list of their affidavit of document. Protection के लिए notice can be given under rule 11 and 14 के अंदर. Both the parties must exchange it completely. उसके बाद discovery होने के बाद, please note that here, then the court will separate the admissions. Under order 12 के अंदर the court can pass a decree on admission. Under 12 the court told you that here, if you admit the claim, decree can be passed. If you don't admit the claim, and the matter will go on before the court. Then how the judgment is passed and admission is order 12 rule 6. Please note this, very important. Notice is given for admission under order 12 rule 4 and rule 5 में judgment is given. Now 13 के अंदर the production, impounding, return of document. Now this is a stage. This should be read along with section 135 and 136 of the Evidence Act. Because examination chief tender किए आपने, issues frame होने के बाद, first issues will be framed after filing of your affidavit document. Issues will be under order 14. There will be issue of law and issue of facts. Please note that order 14 के अंदर देखो order 14 में आ जाइए, issue of law and issue of fact. Settlement of issues में देख लिया आपने A and B. The court has the discretion that issue of law will be decided first. Agar defendant has taken up the plea, the present suit is barred by the doctrine of res judicata. under 11, or the plaintiff had filed similar suit earlier, identical cause of action, and has withdrawn the earlier suit without permission. So you know the effect of withdrawal of the suit without permission. जानते हैं आप? Under Order 23 of the Code of Civil Procedure, a party has a right to withdraw at any stage. But if you withdraw without permission, you cannot file a suit on the same cause of action. So one of the issue frame is here in the written statement take up the plea. The present suit is not maintainable because it is disposed of earlier suit on the same point. This res judicata decree, I got entire proceeding. Or the earlier suit was withdrawn without permission. Under Order 23, Rule 3 and 4 के हिसाब से, the second suit is barred. When you just open Order 23, बता दूं आपको मैं ये. This Order 11 तो तुमको मालूम है, I won't read it. Order 23 is very important. Unless you have not been pointed out, I would like to show it to you, because Order 2, Rule 2 says that the plaintiff ka entire suit must include the entire cause of action. If you relinquish any part, your suit will be barred. You will not be allowed to file a second suit. So please, Order 23 check करें यहाँ पे. Order 23, Rule 1, 2, 3 का मैं बता दूं significance why you cannot file a second suit. Order 23 आ जाइए जरा. Yeah. 23 मिला आपको? 25, 23. Yes. Withdrawal and adjustment of the suit. Pay attention to this here. You are under the criminal law, under the civil law, plaintiff can withdraw the suit anytime. Nobody can oppose it. But if you want to withdraw without suppose you want to withdraw today and refile a suit on the same cause of action, you must obtain the leave. Provided that where the plaintiff is a minor number. An application for leave under so and so shall be accompanied. Minor ka suit cannot be withdrawn. There are situations. Then when you abandon the suit under Rule 4, check kare aap. Withdrawal from a suit or any claim without the permission referred to above in Clause 3. See, Clause 3 कहता है, where the court is satisfied that the suit may fail by reason of formal defect. By sometime you withdraw the suit because court fees is not properly paid. You withdraw. All parties are not joined. You may withdraw. Then that there are sufficient ground for allowing the plaintiff to institute the fresh suit for subject matter for any claim. So you may to tell the court, I may be allowed to withdraw. But it may be in terms it think the plaintiff permission to withdraw from the suit or a claim with liberty to institute a fresh suit in respect of the same cause. Whenever you withdraw, please suppose the less court fees pay kiye aapne, or the parties are not fully joined, or maybe in the wrong court, please withdraw the suit with liberty to file the suit with the same cause of action subsequently. अगर वो liberty नहीं मांगेंगे आप, then second suit will not lie. That provision I will show you here. Yes. Where is the provision? Just see. Yes. Limitation law not affected by the first suit. ये सब amendment आ चुके हैं. I do not want amendment of the various states. CPC amendment देखे. Where is the second suit is hit? Too many amendments of Allahabad and all here. Yes. Yeah. 3A check करो. No suit shall lie to set aside a decree on the ground that the compromise is so and so best. See that when a suit is dismissed, when a suit has been withdrawn, no suit would lie. 3A, ट्री चेक करो आप ऑर्डर 23 रूल 3 के अंदर. Too many amendment. See, compromise of the suit, where it is provided to the satisfaction of the court that the suit has been adjusted wholly apart, lawfully agreement, compromise in writing, where the defendant satisfy the plaintiff in respect of the whole or part thereof the claim. The court shall order such agreement, compromise, satisfaction record and shall pass a decree so and so in the agreement, provided that where it is alleged by one of the party denied by the other, adjustment, satisfaction, court shall decide the question in the matter. An agreement, compromise. Then specific provision. एक minute. Yeah, where is the bar? Can you point out the bar to me, anybody? Order 23 rule 3A. 3A के अंदर bar of the suit. Yeah, agreement to compromise to be entitled to representative suit without the leave of the court. In what cases you can in representative suit under file under order 1 rule 8 cannot be withdrawn without the leave of the court. So when you file a suit and withdrawn without the leave of the court, second suit is barred. So the court will frame an issue in that regard here, whether the issue will be whether the present suit is hit by the provisions of order 23 of the Code of Civil Procedure. Then the court say that here on the point of law I can decide it. So earlier you learned that here under section 11 there is the res judicata. That means earlier suit be decided, evidence is recorded and disposed of. The plaintiff suit is dismissed. After 10 years, 15 years, 30 years, his children are filing a similar suit against the defendant children that you are a trespasser, you are liable to be evicted. So defendant will be having a decree, earlier suit, and point out, my lord, the earlier suit was filed on the same ground against my father by the father of the plaintiff. The decree is in my favor. So the present suit is not sustainable. So the court will frame an issue under order 14, rule 2 on an issue of law and dispose of the matter. But sometime the court will say that will frame all the issues, issue of law, issue of fact. It may be a suit for declaration that you are a owner of the property, that the defendant is having some agreement in his favor from your father, that the agreement is sham, colorable, bogus, be set aside under section 34 of the Specific Relief Act. Then you seek possession, that this honorable court be pleased to pass a decree of possession in my favor. Why? Because I am the true owner. Then you take up the plea that here that the possession of the defendant is unlawful. He should be directed to pay mean profit under order 20 rule 12C CPC. So you have asked for a comprehensive and composite relief under the law of under the Code of Civil Procedure. So suit for declaration, they will be coming essentially under the Specific Relief Act. That you should connect your the Specific Relief Act section 34. Then CPC, then your suit for possession, relief for possession, then permanent injunction, no alienation, section 37, 38, 39 of the Specific Relief Act. Then mean profit, section 2 and order 20 rule 12C CPC uske andar aayega. So the court will frame composite decree in the matter, composite issue. So evidence, the court will say the parties to lead evidence in all that. Evidence ke baad then the court will issue direction parties to complete inspection, discovery and file their affidavit of document. And who should begin? After framing of the issues, who should begin? If the court says that on the preliminary point of the defendant has taken up the plea that the suit is barred by limitation or the suit is barred by res judicata, then the court may say that instead of trying other issues, I will try the legal issues first. Under order 18, when you open, the defendant has to begin. So the defendant has to open order 18. खोल लीजिए जरा. who should begin is mentioned in order 18. Yeah, have you got it? Hearing of the suit and examination of the witnesses. तो वहां पे भी ऑर्डर 10 में भी देखिए आपने एग्जामिनेशन ऑफ द विटनेसेस. That is a examination before the framing of the issues to ascertain what issue should be framed, to ascertain whether the plaintiff and defendants are admitting the claim or not. That is for a limited purpose. Now, a full-fledged trial after framing of the issues, right to begin, order 18. The plaintiff has the right to begin unless defendant admits the fact alleged by the plaintiff and contends that either on the point of law or some other additional fact, allege the defendant plaintiff is neither entitled to any portion of relief which he seeks, in which case defendant has the right to begin. So normally when the plaintiff files a suit for declaration that he is the owner, or files a suit for specific performance of a contract that the agreement is binding and should be specifically enforced, he should file the suit. If the defendant has taken the plea that there is a res judicata or that the earlier suit has been dismissed, he has a right to begin. He has a right to begin defendant under order 18. That is the meaning of order 18 rule 1. How does the beginning take place? Order 18 CPC के अंदर rule 4 में आ जाइए. Now the role of Evidence Act is coming to play. Recording of evidence, order 18 rule 4. Order 18 rule 4 should be read along with section 137 of the Evidence Act. Now see that in every case the examination in chief of a witness, examination chief पढ़े आपने Evidence Act के अंदर 137 में, whoever begins the case and files evidence, that is called his examination chief. Shall be with affidavit copy shall be supplied to the opposite party. Now Evidence Act tells you under section 1, affidavit is not evidence normally, but there is a substantive provision in the CPC under order 18 rule 4 which tells you that examination chief should be filed by affidavit. That means in that event this will be accepted. Even under section 391 CrPC के अंदर पढ़े आपने, formal witnesses can be deposed by affidavit, isn't it? CrPC पढ़े हमने अभी ऊपर गेटा. Now here examination chief will be in CPC as a matter of course will be by affidavit unless the court says that no, let the witness come and depose, provided where the documents are filed. Now along with the examination chief, normally it is a title of the full title, then the plaintiff will say the list of witnesses are given. Please note that before beginning under order 16 खोल लीजिए जरा, there are list of witnesses which are mandatory. Order 16 खोल लीजिए. CPC contains a more comprehensive provision relating to document admission and witnesses than CrPC. CrPC के अंदर left to the discretion of a judge to decide. Order 16 के अंदर rule 1 check कर लीजिए आप, where you have to give the list of witnesses. Order 16. Yeah. Summons and attendance of witnesses. List of witnesses and summons to witnesses. Please note that here. On or before the date of the court may appoint and not later than 15 days after the day on which the issues are settled. Under order 14. The parties shall present in the court list of witnesses whom they propose to either call or give evidence and produce document and obtain summons to the such so and so. Both the plaintiff and defendants are under obligation to file the list of documents. And whom they propose to examine. And whoever is beginning the cause. So, वो document डालने के बाद, please note that once you tender the examination chief under order 18 rule 4 CPC and list of witnesses under the provisions of order 16, why? Because the other side has a right to know who am I going to examine. Then the matter will be kept for, along with the examination chief and documents which are tendered list here, admissibility and denial, and admissibility and relevancy. Denial, other side, the court will issue notice to other side. Look here, the plaintiff has filed the affidavit in chief in examination and documents are exhibited. How documents you produce in evidence? I so and so the plaintiff do hereby take oath and state on solemn affirmation as under. I have filed the present suit for declaration of the title and for cancellation of the agreements of the defendant, which are more specific. I say that I am the owner of the property. To show my ownership, I hereby produce my deed of conveyance evidencing the fact of ownership. This is the original document. I produce the same. This document, this property, I have purchased it from Mr. XYZ. This is a registered document. This is signed by me and signed by the builder or the defendant. The document, this is an original document. It's the same, may be taken on record. The contents are correct. This honorable court be pleased to read the documents in the evidence by marking the same as exhibit. That is how you mention. If the copy, original आपने लिखा आपने, if the copy is originally lost or not misplaced, क्या लिखेंगे आप? The plaintiff does not have in his possession the original. The original document is in possession of the builder, that a defendant who said that he will get it registered and send a copy to me later on, and it is lodged with the registering authorities and it is sent to Pune for adjudication. Under the provisions of the Stamp Act, stamp duty may have been paid, sent for adjudication. So either you issue notice to the plaintiff or to the registration authorities that the original document be produced in the court at the time of the giving evidence. Notice dijiye aap. Because there's a notice under section 66 of the Evidence Act which I told you. The plaintiff at the moment has a Xerox copy. The original is with the defendant. I have given notice to produce. The Xerox copy is the one which has been taken from the original by the builder, the defendant, and he has furnished to me. The contents are correct. So on the day when you commence your evidence, in the box, you may tell the court here, I have given notice, this is the copy. I call upon the defendant to produce the original pursuant to notice. If he brings it, then the original will come on record. Otherwise, you can tell the court, my Xerox copy, which is a secondary evidence, may be taken on record, may be admitted. Okay. So the court, before passing such order, will pass order on admissibility of document. Please open section 136 of the Evidence Act. (136) Just to decide the admissibility of evidence. See that? When either party proposes to give evidence of any fact, the judge may ask party proposing to give evidence in what manner he alleges to be proved would be relevant, and the judge will admit the evidence and think fit and proved and would be relevant. Please remember 136 may the judge passes. Now 136 should be read along with in CPC order 13. Order 13 खोल लीजिए. See, it is all interconnected. You should remember this. Order 13 खोल लीजिए आप. Order 13, come to rule 1. Production, impounding and return of document. See that here at the evidence. Original documents to be produced or before the settlement of the issues. So court ke andar along with the examination chief, what you are producing? Original document. The parties or the pleader shall produce on or before settlement of issues all the original evidence where the parties have been filed along with the plaintiff or written document. So this is the language also of the provisions of section 64 of the Evidence Act. Please note that, remember in mind all these sections. Proof of document by primary evidence. Order 13 CPC to be read along with section 64 of the Evidence Act. We say proof of document by primary evidence. Primary document must be proved by primary evidence except in the after. So what is the primary evidence is section 62. Please, primary evidence mean the document speak for itself, that is the original document. Right. So under order 13, when original document is produced in a civil court, see the court shall receive the document so produced. See that item number 2. Number 3, provided that they are accompanied by an accurate list thereof, separated with from the one from as the High Court directs as per the rules of the High Court, or each court has its own rules. Nothing in the rule shall apply to document produced for cross-examination or handed over. So you need not disclose in your list of documents which you are going to likely to take the defendant by surprise. His own document, isn't it? Even under the provisions of order, the provisions of CPC, that is order 7 rule 14 mein padhe aapne. Exhibit all the document and certain document which you cannot disclose. Under order 8 rule 1A mein defendant must disclose all the document. If he doesn't disclose, he will be debarred. But certain documents meant for cross-examination need not be disclosed. So वो mention करेंगे आप. Then see, need not be mentioned. Suppose you want to impeach the credibility of a witness, the document need not be shown to him. Then see, the court will pass order 13 में, rule 3 में, rejection of irrelevant admissible document. So at the time when the evidence is commencing or before the examination chief is commencing, while passing order under 135, 136 of the Evidence Act, the court will pass this order. I am not taking this copy relevant document on record because this is not admissible. Or the evidence required to be, I am keeping the document for identification. It's a document not connected to this property. The suit property is situated in South Bombay. You are producing document of Pune. How relevant it is? So that will be rejected. So that order rejection irrelevant will be passed under 136 of the Evidence Act. Then the rule 4 may endorsement of document admitted. So under 136 of the Evidence Act, the court is also passing order certain documents I am admitting. So list बना के रखेगी court. The document which I admitted, P1 plaintiff का 1, P2 the passport, P3 the agreement original document, P5 maybe is maybe the what you call it, the Aadhaar card. These are document, public documents are B1, P1, P2 mean plaintiff document. वो defendant के हो तो D1, D2, D3 हो जाएगा. If it's a Xerox copy, the court क्या बोलेगी? The document is marked for X for identification. क्या mean? Let it be proved as per the Evidence Act. X for identification. Then a document is produced, a FIR copy, it is kept as again X for protection. If it is a proved, if you are bringing a will of your grandfather, which is unprobated, it is again X for identification. So endorsement is made under Order 13, Rule 4, read with Section 135, 36 of the Indian Evidence Act. The court will make endorsement under Order 13, very important, please remember it here. Endorsement of copies admitted, Rule 4 and 5, check karo aap. This is the procedure in CPC, which is little slightly a departure from the CrPC. Okay. Then if the court find that certain document is a bogus document or unstamped document, if it is not properly stamped document, court will impound it. Mean under order 13, court order the impoundment will take in custody. Bolenge the defendant or plaintiff is producing agreement of sale, not agreement of sale, it's a mortgage document unregistered. Under the Transfer of Property Act, Registration Act, registration of a mortgage deed is compulsory, isn't it? Any document which is unless it is a agreement of sale need not be registered. There is a provision under 47 of the Registration Act. The Registration Act mandates that here every document above the value of 100 rupees must be registered. Bolenge, my lord, this man is producing conveyance and it is a property worth 1 crore and he is paying only an affidavit of 100 rupees. The document will be confiscated by the court. क्या करेंगे impound करके? The matter will be sent to the sub-registrar for adjudication under the Stamp Act. In Maharashtra, under section 31 of the Maharashtra Stamp Act, there is a central government का Stamp Act will भेजेगा. Till the document is determined stamp, it won't be received in evidence. Under section 47 of the Registration Act, जरा खोलिए आप है तो किसी के पास है, the document cannot be received in evidence. Unregistered document cannot be evidence. It will be impounded. As an alert lawyer, young lawyer, you must tell the court, this document I am objecting because it's an unregistered document. Section 17, 18 of the Registration Act पढ़ के जाइए आप. Please, section 17, section 18, section 47. 47 says that here, documents which are meant for, which is, for example, for a specific performance, it need not be registered. Document for leading collateral evidence of a different transaction need not be registered. Otherwise, if you are basing your claim on a document, unregistered document, seeking possession of the property, court will impound it. Impounding procedure दिया गया है यहाँ पे order 13 के अंदर. Please note that here. As a young lawyer, you should be able to know that. Then देखो that. The please provisions of order 13 पूरा पढ़ के जाइए आप. Is very clever. This is very important. Order 10 के अंदर the court will record evidence and send the matter for mediation, conciliation or record evidence of the parties. 10, 11 के अंदर discovery inspection, 12 के अंदर admission, 13 के अंदर all documents are filed, list of document, and 13 के अंदर admissibility, non-admissibility and impounding document read with order provisions of section 135, 136 Evidence Act. This is a club with the provisions of order 18. Come back to order 18. What is the time now? Time कितना जी?
7:50.
7:50 mean almost 1 hour हो गया.
Yes, sir. More than 1 hour.
Shall we stop it here or shall we take a lecture? Continue करें. बताओ कैसे भी. You want a break? Anybody?
Sir, I think we'll take a break and then 10 minutes
Okay,
will come.
take a break for 10 minutes. Then I will complete the entire CPC. Hope you all are following. Huh?
Yes, sir.
Okay.
We'll come at 8 o'clock then.
Okay, 8 o'clock को आ जाओ. Then 8 से 9 तक एक lecture लेंगे. Tomorrow off कर रहा हूँ मैं. Okay?
Okay, sir.
Tomorrow being a Ganapati festival, everybody enjoy. Huh?
Yes, sir.
Then Monday मिलेंगे हम लोग. Huh?
Okay.
Okay. Please take a break for 10 minutes. Okay. Okay.